All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. We are hearing the case of Prentice v. Pitel. Petitioners, Mr. Evans.
May it please the court, Madam Chief Justice. Good afternoon, Your Honors. My name is Tyler Evans, and together with my co-counsel, Matthew Radler, I represent the petitioner in this matter, Mr. Graham Detroit Prentice. I will be addressing the 10th Amendment issue, and my co-counsel will be addressing the First Amendment issue. The petitioner would like to request 2 minutes of time for rebuttal. This case is about the state's continued sovereignty. The decision of the court below misinterpreted Missouri v. Holland to hold that the federal government may regulate local speech pursuant to the treaty power without regard to the 10th Amendment's constraints on federal authority.
Mr. Evans, I take it that you do not ask us to overrule Missouri v. Holland. Is that correct?
That is correct, Your Honor. The petitioner does not take issue with this court's precedent under Missouri v. Holland. However, the petitioner's argument is that Missouri v. Holland instead stands for the proposition that the federal government may regulate local conduct pursuant to the treaty power only when the principle of federalism is not implicated.
Where do you find that in Missouri v. Holland?
In Missouri v. Holland, Justice Holmes did indicate that the decision did not mean that the treaty power is without qualification. Justice Holmes only indicated, and the only question in the case, was whether an invisible radiation of the 10th Amendment prohibited the federal government's regulation of migratory birds. The federal regulation of migratory birds in that case was not an issue, however, because the states themselves, as Justice Holmes recognized, were incapable of regulating migratory birds under their own state authority. Thus, when migratory birds were outside of the state's jurisdiction or in foreign nations, the states themselves could not protect migratory birds, and thus a treaty was necessary to protect this natural resource for the entire nation.
Well, I don't really quite understand the argument. I mean, it's true that the without qualification language is there, but without qualification might just mean if there's a treaty that violates some other constitutional provision, the Reed v. Covert kind of case, that was a limitation. But otherwise, I'm not sure where you get this idea. In fact, it seems to me that Missouri v. Holland pretty much says that Congress can enact, the Senate can make a treaty, and Congress can enact legislation implementing that treaty, even though Congress doesn't have a different constitutional authorization over that subject matter.
That interpretation is absolutely correct, Your Honor, however, with the one caveat that the principle of federalism may not be implicated. Once again, the federal authority was not invading the sovereignty of the states because the states were incapable of regulating migratory birds.
But in this case, if migratory birds is a matter of the first magnitude, and I think that's the word that was, or the phrase that was used, how is not the prevention of international terrorism of the even greater import and requiring cooperation between international powers? You know, I would agree with you if this was just a treaty that, without regard to what was going on in the world, was put into effect and overrode the states. But don't we need to give deference to the history behind the entering into this treaty?
The petitioner does not take an issue with the importance of the interest at stake here. The petitioner's issue is only with the federal government's mode of action. The federal government may effectuate the interest at issue here by simply regulating the interaction of the petitioner's speech with international terrorists, for example, by prohibiting its uploading on the internet. The federal government may also enact other legislation, such as its spending power, to encourage the states to pass legislation to regulate the petitioner's conduct. The federal government does not, in this case, in order to effectuate these very important interests, need to supplant state law.
Are you really saying that Congress would have to wait until they encouraged all 50 states to enact legislation that was aimed at protesting against particular religions?
No, Your Honor, because the federal government still has the first option of simply regulating the interaction of the petitioner's speech with international terrorists.
So you'd be okay, I'm sorry. I was just saying, you'd be okay if this prohibited the person from uploading what they were doing onto a video or on the internet?
That may raise separate individual right concerns, which are not at issue in the 10th Amendment part of this case. However, under the 10th Amendment, that would be entirely permissible because the federal government has the authority to regulate the means or instrumentalities of interstate commerce, which the internet is often considered to be. Thus, because the states do not have the authority to regulate the internet in that capacity, the principle of federalism is not implicated.
But you're suggesting that the federal government could accomplish the same results with a different approach, but the government negotiated with 42 other countries, joined in the treaty. It's a process of accommodation of different interests. Why shouldn't, once the negotiation, the international negotiation takes place, why shouldn't that be the way that it should be, that we should proceed to deal with this problem? Are you suggesting our diplomats should negotiate and say, but wait, I've got to check to see if the courts are going to approve this before I sign on the dotted line?
Absolutely, Your Honor, because the CRT itself, the Convention on Religious Tolerance, considered that potentiality. The CRT indicated that the member signatory nations must implement the treaty with respect to their own constitutional provisions and may in fact implement it through their member states. If the federal government is incapable of regulating this action because of the principle of federalism, it, by implication under the CRT, may permissibly go to regulate the interaction of the petitioner's speech with international
Well,
terrorists.
what principle of federalism are we talking about? What do you think the 10th Amendment limitation on the treaty power is? How do we know it when we see it?
There are two 10th Amendment interests at stake here, and the first is a direct one. The 10th Amendment protects the incidence of state sovereignty, in this case, the penalization of purely local conduct. The second interest at stake...
Well, stop on that one. I mean, it can't be the case that every time a state can regulate in an area that the federal government cannot. That would be against many, many, many decades of constitutional jurisprudence.
Absolutely, Your Honor, and that is not what the petitioner suggests. The petitioner suggests that the penalization, the ability to penalize or permit purely local conduct that has no effect on interstate commerce, is reserved to the states under the principle of federalism.
Such as licensing a local business?
Licensing a local business may be a civil regulation that, because the business is somehow in interstate commerce, it would be regulable by the federal government. However, the petitioner is more speaking about conduct.
Well, I'm thinking about our precedent overturning, I believe, the state of Washington statute or local ordinance regarding licensing and overturning that as violating our treaty. Are you saying that was an incorrectly decided case because licensing businesses is local conduct, is a local form of regulation protected against federal regulation by the 10th Amendment?
No, Your Honor, because businesses are heavily regulated by the federal government. Since Heart of ELENA, the federal government has often been able to regulate businesses in a very local capacity because of their connection to interstate commerce.
But that wasn't the basis of our decision in that case. It was based just on the treaty.
Well, I'm not familiar with the case, Your Honor. What treaty was at issue in that case?
I think we get to ask the questions.
Okay.
I'll give you the case in a second.
All right.
But here's the problem. First of all, you're asserting, and your client is asserting a 10th Amendment bar to this. But you're saying it was a purely local conduct. But your client's intent was not purely local. He didn't have a gripe with the particular mosque. His intent was to make it national and international, and that's the concern that the treaty is addressing. So I'm having trouble with your sort of analogizing this with the case where they, Coyle versus Smith, where they couldn't say where the capital would be of every state. That would be the location, that's something of local autonomy. But if the only effective way to comply with this treaty is through a national law that has an international effect, the fact that it can be done in another way does not make this law unconstitutional under the 10th Amendment.
Under the 10th Amendment, the petitioner asserts that it would make it unconstitutional because this is an incident of sovereignty. This court's opinions in both United States versus Lopez and United States versus Morrison indicate the importance of penalization of purely local.
But those cases were cases in which Congress did not have power to act under an enumerated power. So the court said there is no Commerce Clause power here. Here, Congress has acted under the treaty power, and you are suggesting that there's an independent 10th Amendment limitation on that. As far as I understand our precedent, we have upheld that idea of an independent 10th Amendment limitation only very rarely, and only when what the federal government has done is essentially to co-opt or commandeer state authorities in Prince or
New York versus the United States.
You got it. That's not this situation at all.
Absolutely. However, the petitioner would assert that there is an implied federalist limitation of the treaty power under this court's precedent. Coyle versus Smith is an important indication of this because the admission power, much like the treaty power, is textually absolute.
But what possible concern could it be to the federal government as to where a capital is going to be? Although I must say, in my home state of Florida, I wish they had put it somewhere other than Tallahassee. But we're again divorcing what your argument, which is intellectually a good argument, from the reality of the international terrorism. And not to sign this treaty, since the United States, if they have the authority to sign it, to be able to effectuate it, the testimony is that it would lower our standing in the international community and it would endanger our foreign policy. So isn't that, again, go back to doesn't that trump the 10th Amendment, being able to have discourse and have our foreign policy asserted around the world?
No, Your Honor, because if the federal government could simply cite international dissatisfaction with the United States' actions, the federal government would not be one of limited power. Missouri versus Holland is a perfect example of this. In Missouri versus Holland, the federal government could not regulate migratory birds pursuant to the Commerce Clause, or as many courts held that to be the case. Thus, it simply phoned up Great Britain, asked them to enter into a treaty with them through Canada, and regulate the subject matter at issue. It expanded its enumerated powers to the subject matter at issue simply by requesting international aid. That was not inappropriate in Missouri versus Holland because the principle of federalism was not implicated. However, the principle of federalism is implicated here.
Well, why was it not implicated there, but it is implicated here?
Because the states were incapable of regulating migratory birds while they were outside of their jurisdiction. Thus, there was a gap in sovereign authority between the federal government and the states.
But the states could have, under your same logic, each state could have decided that the federal government could say, we want each of you to enact legislation for birds flying over your own state.
No, Your Honor, they could not do that because they would be directing state action. Much under New York versus the United States, the federal government may not dictate state legislation. Instead, the federal government had to pass a law pursuant to the treaty power because there was no other enumerated power that would cover the subject matter and regulate migratory birds at a national level.
Let me return to the Asakura case.
Okay.
Okay. Now that's a case in which a local ordinance forbid aliens from being licensed in certain businesses. And we overturned that because of a treaty with the Japanese saying we could not discriminate against Japanese citizens. Now, why was not that a perfectly local matter?
Absolutely, Your Honor, and I apologize I did not hear your case citation earlier. Absolutely. Asakura is within the petitioner's, fits within the petitioner's argument because in Asakura, foreign nationals were being regulated. The federal government, pursuant to the treaty power, achieved an otherwise unobtainable end. There, the federal government granted privileges and immunities to foreign nationals in the United States to gain a reciprocal grant of such privileges and immunities to American citizens while abroad. There was no invasion of the principle of federalism because the states are incapable of regulating foreign nationals in the same capacity.
But the local law didn't have to forbid aliens from having licenses. you're saying as long as we get a quid pro quo from another country, then the treaty power authorizes treaty provisions that overturn local ordinances. Is that what you're saying?
Yes, once the treaty
So
power...
why isn't that the case here?
That is not the case here because the treaty power is not obtaining an otherwise unobtainable end. The treaty power was necessary in that case to gain concessions in Japan. The treaty power is not necessary here to frustrate international terrorist recruitment efforts, as the federal government can
Well,
simply...
who are we to say that? Who are you to say that? How do we know?
Well, the federal government can simply regulate the uploading of the petitioner's conduct to the internet and reach the same goal. Your Honors, I see that I'm out of time.
Thank you, Mr.
Thank you very
Emmons.
much.
Madam Chief Justice, Your Honors, good afternoon. My name is Matthew Radler, here today on behalf of the petitioner, Graham Detroit Prentice. This court has drawn an express distinction between independent advocacy by an American citizen and conduct which implicates speech which is to the direct material benefit of a foreign terrorist organization. The International Responsibility and Leadership Act crosses that line, and in doing so, it violates the free speech clause of the First Amendment. Thus, even if this court were to conclude that the 10th Amendment is not violated by the enactment of the IRLA, it remains unenforceable and void against the petitioner or any other American citizen, Section 1A in particular.
I have to say, Mr. Radler, that argument surprises me. It seems to me that you have much more powerful arguments to make than that this case is on all fours with Humanitarian Law Project. It's not.
No, Your Honor. While the specific context in which this case arises can be said to be more factually similar in some ways to Snyder versus Phelps, or as well as some of these courts' earlier precedents, such as Booz versus Berry or Texas versus Eichmann, the flag-burning precedents, it is appropriate to recognize that this court was careful to delineate when deference to Congress and the executive would permit the regulation of domestic speech on a national security theory or on a national security interest. Because the IRLA is ultimately justified, by whichever way the government chooses to explain it, by the unpopularity of the speech with a foreign or international audience, it thus remains invalid because, as a content-based statute that regulates speech in traditional public fora, it must be subject to strict scrutiny.
Would you be happy if with this law, if the caveats that your co-counsel had mentioned were engrafted into it? That is, that your client could burn the Quran outside of the mosque, but nobody could watch it and it could not be uploaded to the internet? Wouldn't that just be contrary to his exact purpose, which was to bring national and international spotlight to his protest against Sharia law?
Oh, yes, Your Honor. Were the federal government to attempt to regulate this issue or serve its interests in that manner, such as barring dissemination of the imagery on the internet or by denying the attendance of anyone to the protests, that would raise constitutional concerns also.
But that's what your co-counsel argued. You're on the same side. He said, seriously, that it would be different, it'd be okay if they if the government didn't allow the images to be uploaded on the internet. And to me, from what I've understood about all these protests, it's the very intent that they not be purely local, that they have national and international visibility.
My co-counsel was merely alluding to the fact that in the 10th Amendment context, that would be permissible. Such action by the government would not strike at purely local conduct and thus would be within an enumerated power such as the commerce power to regulate the internet. However, even if the 10th Amendment were not a bar to such an action, the First Amendment categorically would be, particularly the freedom of the press being directly implicated by barring dissemination of the speech issue.
Could you win under intermediate scrutiny? I see that your brief is all about why strict scrutiny should apply. What happens if we disagree with that?
Even under intermediate scrutiny, the interest asserted by the government remains invalid under the First Amendment. And the reason being because this interest is ultimately inseparable from the mere unpopularity of the message in a foreign audience. Now, it is our contention today that this is a content-based statute and thus intermediate scrutiny would be inappropriate. However, under either theory, the problematic interests being asserted by the government, which are not compelling, doom the statute even as narrowly tailored as it may be. Now, to return,
How could you say that it is a attenuated interest when all of the testimony is that when the Quran is burned and seen in international community, it will spark violence and even death. This is not speculative. It's not like flag burning where you have the ability that if someone burns a flag, someone doesn't like it, police can come in and take care of the reactor. Here we have the international interests of this country and the safety of this country ultimately at stake. Should that not be a valid concern of this court?
Under the First Amendment, it is not a valid government interest to assert, because ultimately, the violent reprisal killings and riots that occur overseas are inseparable from taking offense, the unpopularity of the speech being conveyed. The First Amendment does not recognize that as a valid reason for restricting or regulating speech.
What if your client knew that people were... We have a case in Florida where the preacher burnt a Quran and there was actual violence. What if your client, if it was established that he knew that every time this Quran was burned in visible forum, or that it actually caused violence and death?
Here again, the difficulty lies in the disconnect between what the speaker is doing in this case, which is engaging in expressive conduct through the destruction of a religious object, and the misconduct of criminal third parties, downstream actors. Notably, in this court's decision in Ashcroft versus Free Speech Coalition, this court rejected as not compelling the government's purported interest in criminalizing virtual child pornography on the theory that it would prevent downstream third parties, child predators, from being able to use that imagery as a way of seducing or enticing children.
Now, this is expressive conduct, as you just said, and I thought that the lesson of O'Brien is that expressive conduct is treated differently from pure speech, that we use a kind of intermediate standard to deal with things like draft card burning. Why shouldn't we do that here?
Absolutely essential to the O'Brien standard, its very first element is the content neutrality of the law at issue. Here, the statute is not content neutral, and thus intermediate scrutiny is unavailable.
Well, why not? This is not a Johnson situation. In Johnson, the statute itself referred to the speaker's intent as to give offense to those who witnessed the expressive act. Here, there's nothing like that.
Yes. This case aligns more closely with when the federal government attempted to regulate flag burning in United States versus Eichmann. In an attempt to correct what the court found problematic in the original statute in Texas versus Johnson, Congress once again attempted to regulate flag burning in the interest of preserving the symbolic honor of the flag, but this time the statute only struck at specific types of actions.
And what the court said was that the statute used a series of words that suggested disrespectful treatment. But here, those kinds of words do not exist on the face of the statute. It's destroy or burn. Maybe deface is the only one that has a link with Eichmann.
That list is certainly comparable to the list found in the statute in Eichmann. Perhaps the only one that's really
Eichmann
missing
was
is...
trample and mutilate. It said burn was different.
Well, it did hold out the possibility that one could respectfully burn the flag, and the court further relied on that text as well to be certain that it only struck it.
But the interest of what might happen with our fellow Americans if they find the speech offensive goes to the core of the First Amendment. But we have a different situation, especially post 9/11, of international terrorism. It's a fact of the modern world. In this statute, your client isn't prohibited even from burning the Quran, only burning it at a time that a service is occurring at the mosque or at any religious institution, and only within a certain number of feet. How could he could do it any other place that he wanted to do it. He could do it in front of the U.S. Supreme Court. He could do it in front of any place else, but just not then for that limited time, which is in accordance with what the international treaty required. Why isn't that, with the compelling interest of international terrorism, a narrowly tailored statute?
I do not dispute today that the statute is narrowly tailored. The problem lies in its subject matter and the interest that sustains it. While the reach of the statute in practical terms may be quite narrow, it is a dangerous precedent to allow the federal government, on a largely undifferentiated theory of national security, which depends on multiple steps between speech and eventual criminal behavior, to use that as a justification to pick which messages are or are not to be tolerated in public fora.
Well, but this, as Justice was just saying, it's very tolerated. It could be, he could burn a Koran in front of the Supreme Court building. He could burn it in front of an embassy of a Muslim country. He could even burn it in front of a mosque, as long as it's not during prayer times. That's a very limited restriction. The message can be conveyed many ways, and in fact, your client gained fame by burning it in front of, it was not a mosque. I can't remember what sort of public building it was. And that was conveyed on the internet and made him famous. Why is this not such a limited restriction that the justification for it is sufficient?
In this case, the narrow tailoring of a statute is ultimately a separate inquiry from the interest that sustains it. The two cannot be found along a sliding scale once strict scrutiny is invoked. And to reference an earlier point, another reason why this statute is content-based can be found in the question you just posed, and as well as Justice Periente's question earlier, which is that this statute operates by reference to the standards of third-party institutions. Under Booz versus Berry, that is a content-based statute. There, a D.C. picketing ordinance referenced the policies or views of foreign governments. This court found that while the statute did not strike at a single viewpoint, it struck more broadly at an entire set of subjects. Similarly, in this case, the policies or times of the religion at issue, their religious site, define when the statute's prescriptions are in effect. Under the logic of Booz versus Berry, that is properly deemed content discrimination. Once strict scrutiny is applied, however narrowly tailored the statute may be, we must sustain the interest as a compelling one. And this interest is not compelling because, as I alluded to earlier, it attempts to use the downstream misconduct of third parties as a basis of regulating independent advocacy by American citizens.
I guess I just
direct.
don't understand that, Mr. Radler. I mean, it seems to me that as between the question of whether there's a compelling interest here and whether this statute is sufficiently narrowly tailored, your stronger argument is the latter. Of course there's a compelling state interest here. The compelling state interest here is in preventing terrorism.
In this case, the statute does not, in effect, prevent terrorism so much as it attempts to silence a particular viewpoint or at least disfavor it in certain times and places.
But the
in the
state
hopes that
interest in back of the law is to prevent terrorism. Now, you can argue about the chain that leads from the speech to the prevention of terrorism, but that's the compelling interest in this case.
Well, petitioner maintains its position that, particularly under Ashcroft versus Free Speech Coalition, that inversion of the First Amendment to allow a downstream negative act to justify the regulation of speech in the first instance, which this court squarely rejected in that case. It explicitly said that it would turn the First Amendment on its head to permit the regulation of lawful speech to prevent later unlawful acts by third parties.
How about the statement in Texas versus Johnson? We have not permitted the government to assume that every expression of a provocative idea will incite a riot, but have instead required careful consideration of the actual circumstances surrounding such expression, asking whether the expression is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Doesn't the record in this case, which I think we can do a de novo review of the statute, but actually the record in this case established that direct link. Burning of the Koran, riots and death in other parts of the world against innocent civilians. And your client knew about that, certainly before he undertook the actions he took in this case.
In this case, the record satisfies the second prong of that discussion in Johnson, but it fails the first. While we may be able to point to the eventual outcome of violence abroad, there has been no showing that the petitioner in making his speech is inciting anyone to violence. Were the government to assert the Brandenburg standard for direct incitement, they would have a great deal of difficulty prevailing because of the great attenuation and the lack of intent on the part of the speaker for violence to result. Thus, while the second prong of that discussion in Johnson may be evident here, the first is not.
I think here's the problem for you, Mr. Radler. You have an extremely compelling state interest, which is the prevention of terrorism. You have an extremely narrow restriction, as Justice HARTZ suggested. And you have an area, the prevention of terrorism, in which we've said in Humanitarian Law Project most recently that we give a fair amount of deference to the legislature's own understanding of cause and effect. And so put that all together, how do you win?
In this case, the petitioner must prevail because, as this court stated in Holder versus Humanitarian Law Project, there is an express distinction, both in terms of where that deference is due. Your Honor, I see I'm out of time. May
You
I
can finish
conclude?
the sentence.
Where
You
deference
can
is
even
due
make
to
it a long sentence.
Deference may be due to the executive in matters of fact-finding when speech is part and parcel of direct material aid to terrorist organizations. But when the subject matter is independent advocacy, the First Amendment does not recognize a national security interest in suppressing free speech. Thank you.
Madam Chief Justice, may it please the Court, I'm Devin Anderson, and I'll be handling the 10th Amendment issue for the government. With the Convention on Religious Tolerance, the United States, along with 41 other countries, have undertaken a joint effort to eliminate a potent tool of international terrorists. The International Responsibility and Leadership Act, which implements the Convention on Religious Tolerance, is a constitutional exercise of Congress's power under the treaty and necessary and proper clauses. The IRLA is a proper exercise of the treaty power because under the test articulated in Missouri v. Holland.
Could you explain that to me, Mr. Anderson? You talk a lot in your brief about the test articulated in Missouri v. Holland. You say it's a two-pronged test. And, you know, I read Missouri v. Holland 3 times this morning, and darned if I could even find one prong, let alone 2. So where is this two-pronged test?
The two-pronged test is how the government would describe what happened in the Holland case. The government certainly concedes that the two-part test isn't articulated as such.
Okay, so a two-part test is not in the Holland case, and it's not in any other case that we have written that has talked about the Holland case. Is that right?
That's right, Your Honor.
It's just your invention about what kind of test you want in this case.
I think it's a descriptive matter of what the courts have examined and what happened in Holland. The court in Holland first looked at the treaty and whether or not the treaty in that case regulating migratory birds addressed a matter of international concern, which was the preservation of the food chain in that case. And then it recognized that the individual states were, as Petitioner noted, incompetent to act. And those are the two prongs. The court first inquired whether the treaty addressed a matter of international concern, and then whether or not that regulation of that subject matter required consistent national application among the states.
You see, it seems to me that you're trying to find a limiting principle in Holland, and I appreciate that because if you don't find a limiting principle in Holland, Holland takes over the world. But Holland doesn't actually have a limiting principle, does it?
Well, Holland articulates the matter of international concern, which then in City of Asakura, this court...
But what does that mean, a matter of international concern? Is that just any matter that is the subject of a treaty?
It could be read that way, but it could also be read to require that there be some sort of cross-border effects stemming from the subject matter of the treaty. And all of the cases that have upheld Congress's exercise of the treaty power, in all of those cases, the subject matter had such cross-border effects.
The cross-border effect here is that people in other countries may not like what we do here, even though it doesn't affect their citizens and it's a purely local affair otherwise. If they don't approve of our policy on any particular issue, they could say, if you don't enter into this treaty and stop doing that, then we're going to be upset. We're not going to let you have military bases. We might even bomb one of your embassies. There's nothing more here, is there?
Well, there is more here. Certainly there is this foreign affairs interest in the fact that other states were threatening to withdraw military bases if the United States did not ratify the Convention on Religious Tolerance. But the core interest was eliminating this potent tool of international terrorists to recruit others to their cause.
Well, but that could be anything we do in this country. Say there was an infanticide treaty. Say we joined an infanticide treaty, and it include a prohibition on abortion, because there are countries out there that think it's intolerable that the United States permits abortion. Then could we enter into a treaty, this infanticide treaty, and then have a statute that says no state shall fund abortions, no insurance company shall pay to reimbursements for abortions? Would that be consistent with the 10th Amendment?
That would be consistent with the 10th Amendment so long as there had been demonstrable connection between that conduct and international effects. But
Well,
it would.
these other countries are going to be very upset with us. They'll bomb our embassies. They'll end the leases for our military bases. It's purely that they don't like what we're doing. And if they don't like what we're doing, then we can pass a treaty that gives Congress authority to do things that would otherwise certainly not be within Congress's power. And I don't see where you're setting a limiting principle to that, as long as they're sufficiently upset with what we're doing here.
Well, the limiting principle in Your Honor's hypothetical would be the due process right, the substantive due process right that has been recognized regarding abortion. And Reed emphasizes
Not on
that
funding of abortion. I'm not saying that we would have to prohibit abortion under that treaty, but if the statute was limited to just saying no state can fund abortion, no insurance company can reimburse for abortion, so it's consistent with the present law regarding due process, substantive due process. But such legislation would probably not survive 10th Amendment scrutiny. How would that be different from this case?
Well, in that case, so long as there, in Your Honor's hypothetical, so long as the record evidence that there were direct cross-border effects stemming from the lack of, in that case, the lack of regulation on that conduct, the 10th Amendment would pose no bar to Congress entering into such a treaty. Now, there might be other prohibitory...
So all the two-thirds of the Senate and the President need is to have some other country that can make a point that they disapprove of something being done in this country, enter a treaty, and then Congress can pass a statute implementing the treaty that would prohibit this conduct, even though Congress otherwise couldn't. That's what you're led to, isn't it?
If the sole basis for the treaty was the defense of other nations, that would present a different question than the question here, where there's another core interest being implicated, and that interest is the national security interest.
But suppose that that didn't exist. Suppose that there were no evidence that the burning of these religious items provoked acts of terrorism. But there was this treaty and there was this act, and it was just that people felt it was very important that religious items not be disrespected, that it was part of religious freedom. And so that's why the United States entered into this treaty, and that's why the United States passed this bill. Would that be sufficient?
That would be sufficient, Your Honor, because under the Constitution, Congress has broad power to address matters dealing with foreign affairs and our interactions with other nations.
Well, how does that deal with foreign affairs? Just because it's entered into a treaty. So now your limiting principle is not very limited.
Well, it does deal with foreign affairs, Your Honor, because it deals with the United States in its interactions with other countries.
Well, treaties necessarily do that.
That's right. But the treaty, as I understand the hypothetical, is stemming from discussions and interactions between U.S. diplomats and diplomats of other countries.
But then you're saying that there truly is no limitation on the treaty power, even if Congress is acting in a way that it couldn't do through domestic law. Because once there's a treaty and you're dealing with other countries and there's been a negotiation, you're saying that alone is sufficient.
That is sufficient because in that case there are cross-border effects. Now the test is admittedly a broad one, and this court has recognized that the treaty power, Congress's power to implement treaties, is of a necessity broader than its power to otherwise pass domestic legislation.
Does this treaty depend on all of the signing nations enacting similar laws?
It does not. There's
no reciprocity. So really what's happening is this is being used to suppress freedom of speech without any evidence that it will have an effect on international terrorism, which by its own definition is lawless. It's sort of, well, we're going to kill all those terrorists. Well, we have no power to do that. So my concern is that this is very different than migratory birds. Maybe the interest stated is more compelling, but the means to achieve it are truly going to be ineffectual. And does that matter? That not only that it infringes on free speech, but that the methods chosen make no sense. I mean, this guy if he can protest any place and it will go on the internet, it just has no relationship to the idea that we are going to prevent international terrorism by stopping this one person from burning a Koran outside of a mosque.
But the record reveals otherwise. The record reveals that a study conducted by the United States with several of the other nations involved in the Convention on Religious Tolerance established a direct correlation between the protests regulated by the CRT and the IRLA and terrorist recruiting efforts. This is not a case where there's some sort of hypothesized connection.
But they're actually, what they found was a much broader concern. It was any disruption of Muslim services. It wasn't just the burning of the Quran. So what they found to incite was not just this one act. It was anything that would offend the Muslim religion. Isn't that true?
Well, certainly the findings swept a little broader than the statute
Very
actually.
much broader, so that we would have to say, really, to be effectual, we would have to stifle everybody from criticizing the Muslim religion at any time and any place.
Well, it's the effect, whether or not the statute would be effective, I think is supported by the record, which indicates that this type of conduct, granted in conjunction with some other types of conduct, but this core type of conduct that was the concern of the UN Secretary General when he initiated the process for making the treaty, and then the Secretary of State has that direct connection. Secretary Tiff testified in the record that there is a connection between the protests regulated by the IRLA and efforts by terrorists abroad to recruit others to their cause. And that demonstrated cross-border effect falls easily within the broad grant of treaty power under Holland and City of Essex.
Mr. Anderson, could I take you back to Justice Hartz's hypotheticals and give you another one? A group of countries got together and they decide capital punishment is immoral. And they ratify, they agreed to a treaty to that effect. It's ratified, implementing legislation. Capital punishment is banned in the United States as a result of this treaty. Perfectly fine?
So long as there's been a demonstrated connection between the lack of capital punishment or the lack of capital.
So here's the only connection. The only connection, as in Justice Hartz's example, is that other countries think that capital punishment is immoral and have said that they'll be very upset with us if we don't do something about our criminal justice system. That's the only connection.
In that case, Your Honor, because it directly implicates our relationships with other countries, that would be a permissible exercise of Congress's treaty power.
Okay, so if that's the case, then there are no limits on Congress's power, because whatever it can't do through domestic legislation, and obviously the Commerce Clause and other powers that Congress has sweep widely, but at some point they run out. And now when they run out, the government can just go enter into a treaty and keep on going. And so there are no limits at all.
Well, they're structural. There are built-in limitations in the treaty-making process that preserve the rights of the states and
those are political limitations. It's just that sometimes you won't be able to find treaty partners. But you're saying that there is no constitutional limitation. Whatever one can't do through domestic legislation, one can do through treaty making.
So long as it directly bears on foreign affairs.
What treaties always do, you just told me.
Well, not necessarily, Your Honor. Can
you tell me a treaty that doesn't bear on foreign affairs?
Not off the top of my head. The issue with when a treaty has been made, certainly that the conclusion of the treaty is evidence that foreign affairs powers of Congress have been implicated. And so in that sense, the limitation is the making of the treaty itself. So Holland directly directs the court to look at the subject matter of the treaty and its relationship with either the foreign affairs power or whether that subject matter has cross-border effects itself.
But I am hearing you say that the very act of entering the treaty is going to mean that it is a subject that is proper for the federal government to exercise as far as vis-a-vis the states. Is that correct?
There are other limitations on the treaties, but as far as the process,
about the constitutional
as far as
limitations?
yes, Reed says that a treaty cannot violate the specific prohibitory provisions of the Constitution. So in Reed, you couldn't enter into a treaty that would violate a criminal defendant's rights under the 4th, 5th, or 6th Amendments. And as the discussion was during Petitioner's argument, there could be federalism implications if Congress entered into a treaty that adjusted the mode of a state government, that directly bore on that. But when the 10th Amendment itself is not a limitation at all when Congress is acting pursuant to its treaty power, because the states have delegated all of the foreign affairs power to the federal government, and that's
So
explicit.
you're really of the view the 10th Amendment is of no effect in the Constitution, the right of states to local autonomy. And unlike the Commerce Clause, which is interpreted, what you're saying is this court needs to defer to the expertise of the government in deciding that it's a proper subject, and if they do and they go through that process, that's the end of the inquiry.
That's correct. The 10th Amendment itself poses no limitations on the subject matter that a treaty could enter into, leaving aside the question if a treaty would alter substantively the character of a state government.
And we can't even question whether it has international effects or not? I mean, in other words, whether it is actually a pretend international effect or a actual international effect?
I see my time is up, Your Honor, but I'll address that question if that's all right.
You can respond briefly.
And the record in this case clearly indicates that there has been an established connection. This is not a situation where the connection is simply hypothesized or where there would be a legitimate inquiry into pretext. And where there would be a legitimate inquiry into pretext, this court might try to ascertain whether or not that was the case here. But this court has consistently been reluctant. Thank you, Your Honor.
Madam Chief Justice, and may it please the Court, my name is Sam Cowan and I represent the government. The IRLA is a critical part of the United States' continuing war on terror. The law creates buffer zones outside places of worship that limit certain types of protests.
Well, suppose this, Mr. Cowan, suppose that there were a law that said there will be no anti-religious speech between noon and 2 o'clock within 100 feet of a church. Constitutional or unconstitutional?
It would depend, Your Honor, on whether there was direct evidence, as there is here, either by testimony of the executive or by a third-party study linking that type of conduct.
Well, let's start with this one. In my hypothetical, does one have to apply strict scrutiny?
No, they would not. Because
Why?
there, it would depend on the interest. But if the interest there was, as is the case here, linked to national security, the test is the government's stated motive, the government's purpose.
No anti-religious speech. What we usually look to is if something is a content-based speech limitation, it provokes strict scrutiny. My hypothetical, content-based speech limitation.
There, your statute singles out anti-religious speech. So it's different from this case in that this case does not single out anti-religious speech.
Of course it does. How does you cannot burn or deface a religious text. Somebody who is favoring the religion is not going to burn the religious text. Of course it is aimed at anti-religious messages.
Your Honor, that the conduct is typically associated with a particular viewpoint or a particular message is not in and of itself disqualifying. If that were the case, then certainly a case such as Hill, dealing with protests outside of abortion clinics.
But that was to restrict access of the people that wanted to go into the clinic. This particular provision has nothing to do with whether Muslims or Jews or Christians could get into their place of worship. That's not what the international treaty is about. This is about preventing anti-religious messages to provoke so as to prevent the provoking of demonstrations.
This provision is about preventing terrorist strikes and preserving diplomatic relations with allies. And as was the case in Hill, the court determined that the interest was sufficiently divorced from the underlying conduct that it could be deemed content neutral.
Right,
the interest depends totally on the reaction of the listener to this conduct. Isn't that correct?
Not necessarily, Your Honor. With regard to the interest in preserving diplomatic relationships, it has nothing to do with, for example, the foreign government's reaction to the speech. But again, even if there is, with regard to the interest in terrorism, it does in some sense turn on their reaction to the speech, that also is not in and of itself disqualifying under the content neutrality test, because even in cases such as Hill, where it prohibited leafleting and educating. It was not a mere obstruction statute. In some sense, that also turned on the patient's reaction to the speech. And it wasn't merely that they were being obstructed from entering, it was that they were offended by the message of the anti-abortion.
The statute in Hill was not a statute that focused on a particular message. In fact, it applied to all messages equally.
So too here, Your Honor, there is no specific requirement, as there was in Johnson, that the individual articulate a particular message, an anti-religious message. In fact,
Would you take this to be something other than anti-religious expressive conduct?
The statute?
Is anti-religious speech content-based? No anti-religious speech. Is that content-based?
That would be content-based.
That would be content-based.
Yes, Your Honor.
So now it's no defacement of religious objects. What's the difference?
The difference there is that is in the government's motive. The test, when there is a time, place, or manner restriction, as there is here, is whether or not the government passed the law out of disagreement with the message. And here it's...
The motive in my hypothetical case and in this real case is the same. What people are worried about is that anti-religious speech is going to provoke certain violent behaviors.
The difference, Your Honor, is that there is a pretextual concern there, where your hypothetical prohibits all anti-religious speech. That is not the case here. Mr. Prentice is free to express himself in other means not implicated by the statute. For example, he could hold up a sign, or he could orally express his message. So here, the Congress balanced two interests. First, that of national security, and second, leaving open ample avenues for individuals such as Mr. Prentice to express...
The problem with the statute, in my view, it's overbroad and too narrow. It's overbroad because you had to presumably protect the fact of not discriminating against one religion. It now eliminates anybody from protesting outside of any religious institution, even though the treaty had nothing to do with the Catholic Church, Jewish synagogues, Presbyterian churches. On the other hand, it will have no effect on stopping international terrorism because they can burn the Koran any place and any time other than 10 feet away. They can be 50 feet away. Well, it's still going to have, if it's televised or photographed, it's still going to have the same exact effect. So you're at the risk of preventing somebody's free speech. You have penalized everyone else from speaking freely as they chose. And then on the other hand, it's ineffectual because it is only on certain hours and in certain locations.
I'll take your overbreath and underbreath in turn. First, with regard to overbreath. Importantly, petitioner conceded and doesn't dispute that the statute is narrowly tailored. But even to the extent that the court were to examine it, first...
Do we have to take a petitioner's concession?
No. First, there were certainly Establishment Clause concerns. The Congress here could not have passed a statute limited to preventing conduct outside mosques, or it would surely have favored those adhering to the Islamic religion over others. But secondly, even if the court were to further examine the law, this court in Humanitarian Law Project determined that where issues of national security are concerned and where the Congress and the executive are determining what types of conduct implicates national security and what is not, they are afforded great deference, and that to the extent that they reach broader, the court there said that they must, of a necessity, brush with a broader stroke than they would in domestic matters. So great deference would be given here to the executive's conclusion in the record that the breadth of the statute is necessary to reach their international security goals. But third, certainly the record would have to be developed more to tease out the connection between other types of religious protests and national security. But importantly, this is an as-applied challenge focused on the very type of conduct that the United Nations study discussed, that of destroying religious objects outside of a mosque. And there, the United Nations study found a direct correlation between that type of conduct and international terrorism.
Let me ask you about the elephant in the room. If the treaty were codified as a statute and the conduct prohibited by the treaty were made unlawful, and just that, statute would clearly violate the First Amendment, would it not?
It would, Your Honor, yes.
So how can a statute be valid if it's effectuating a treaty that is clearly has a religious content basis?
Because the inquiry would be separate here. The Congress went to great lengths to ensure that the law enacted pursuant to the treaty was consistent with its other constitutional...
But the treaty also has to satisfy First Amendment concerns, does it not?
Under Reed, yes, the treaty itself would.
Are you saying that Congress can pass Senate can approve an unconstitutional treaty, but then Congress can enact a statute to effectuate even more than the treaty requires because that's necessary and proper to effectuate this unconstitutional treaty?
That's not what we're saying, but the government posits that the treaty itself passes constitutional muster. But there...
I thought you said just the opposite before, so clarify what, if just the treaty is or is not a violation of the First Amendment?
The treaty itself would not be a violation of the First Amendment, no. Because there, it would certainly perhaps fail under the first prong of the First Amendment, which is content neutrality. There, the government would concede that it would be content-based, but it would pass strict scrutiny under humanitarian law projects.
Why do you think that that would be content-based but not the statute?
There would be evidence that they were singling out a particular viewpoint, a particular message. And here, so the government motive, the government would concede...
Anti-Islamic speech, you're saying, is what would be singled out.
Certainly, Your Honor.
And what's the difference between that and anti-religious speech?
The difference is
both
that...
are singling out a particular viewpoint. One is a narrower viewpoint than the other, but anti-religious speech is being targeted, whereas speech respectful and favoring religion is not.
The government does not agree, though, that the statute targets anti-religious speech. It does target conduct that is typically associated with a particular group, but as Justice Souter stated in concurrence in Hill, that is not disqualifying. The inquiry, again, is whether or not the government's purpose in enacting the treaty was to express disagreement with those protesters' messages.
Could a state under the First Amendment do this exact same thing because they were concerned about the reaction to the burning of religious texts? Would that be the same analysis at the state level, that a state could pass this law as well?
If there was the evidence, as there was in this case, that of studies finding a correlation between that conduct and international...
So if we now get into post-Texas versus Johnson and people are more polarized in this country, and whenever there's a flag burning there is incitement on the other side, then we are going to not protect those that are expressing an unpopular viewpoint. Isn't that the antithesis of the First Amendment?
No, because the difference, though, Your Honor, is that in Texas versus Johnson, the statute reached far broader. It reached essentially all flag burning in all places. The difference here is that the statute singles out the conduct that the study deemed to implicate international terrorism. So the difference in your hypothetical, Your Honor, would be that it would sweep far broader, that the concern would be that the government had pretextual motives. That's not the case here.
No, it's not pretextual. They see actual evidence that when there's flag burning, when there's religious text burning, that people react violently. You know, just think of the case involving the Under God and the Pledge of Allegiance. People get very not just irate about it, they are incited to maybe do things that are violent. Isn't that then they're supposed to be punished, not that you punish the person that's giving the offensive speech?
The difference here, though, Your Honor, is that it implicates international terrorism and international relations. In Your Honor's hypothetical, it's a mere incitement statute.
So any time that a foreign country acts unreasonably, then this country can enter a treaty and limit our citizens' First Amendment rights?
No, not in every case, but whereas...
Well, if there's because what if, there's been demonstrations in Israel by the ultra-Orthodox against women that are not dressed modestly? What if protests here against that particular thing and incited violence there? Could we, and we entered a treaty, could we stop protest against that ultra-Orthodox practice?
The critical inquiry would be whether or not, in Your Honor's hypothetical, the government, as it did here, left open numerous other forms for the individuals to express their message. the government would concede that if, in response to that evidence, they passed a whole-scale ban on the expression of that type of conduct, then that would that would be a different case than it is here. But here, the law is so narrowly drawn.
But that's only relevant if we decide that this is a content-neutral law. If it's a content-based law, the fact that it applies only between 10 and 12 in the morning, or the fact that it applies only at a particular location, wouldn't matter. You can't prohibit speech against the government between 10 and 12 at a particular location. So the question for you really is it content-based?
And it's not, Your Honor. And again, the key is that the government's motive here is reflected both in its stated purpose, but in the narrowness of the law.
Now, the question that O'Brien says we have to ask is the interest related to the suppression of expression? Mm-hmm. And here, the interest is related to the suppression of expression because unless expression is suppressed, the riots, the violent demonstrations and acts will not take place. So it's key that this statute targets the communicative effect.
The law targets the conduct itself, and it's distinguishable.
Because of the communicative effect of the conduct, not for any other reason. Because the conduct provokes violence abroad.
But there is a second interest, importantly, which deals with international affairs.
But if we go to strict scrutiny, do you lose?
No,
Does the government lose?
We don't lose. First, it furthers a compelling interest, that of national security in international affairs. And at the tailoring phase, this court would be guided by Humanitarian Law Project, where the court gave great deference to the executive and the Congress's determination that, Your Honor, I see I'm out of time.
You can finish the sentence.
Their determination that the conduct itself was sufficiently narrowly tailored to reach the international affairs and national security concerns. Thank you.
Thank you, counsel. Thank you, counsel. We'll take the case. I haven't done this Chief Justice thing very often. I'll tell the real Chief Justice that he doesn't have to worry about his job. Counsel.
Your Honor, 2 brief points. The first, respondent elides the difference or ignores the distinction between intent and the operative effect of a statute in being analyzed under the First Amendment. This court recognized in United States v. O'Brien that an illicit motive or an unlawful motive would not invalidate an otherwise constitutional statute. The converse is also true. The most benign motive of the federal government will not save a statute which by its text is unconstitutional. Expanding on that, every interest put forth by the government and discussed just by the respondent ultimately ties back into the unpopularity of the petitioner's message and speech. The statute is tailored to prevent that speech from being disseminated in a particular manner that the media finds attractive and that makes this message more widely distributed. It's hardly a saving grace of the statute that it's effective at suppressing that particular mode of communication. Further, under this court's decision just last term in Snyder v. Phelps, this court reaffirmed the bedrock fundamental principle of the First Amendment that unpopular or even offensive speech is entitled to protection not only from criminal sanction, but also from civil damages and fines, just like the civil enforcement mechanism this statute provides.
In terms of whether there's a compelling interest here, can we not weigh the terrible consequences of a particularly limited amount of type of speech in terms of inciting terrorism against the very limited restriction on this speech? Because there are so many other ways for Mr. Prentice, your client, to express his view. And he has used those other ways and gotten a lot of attention for that. Is that not part of the calculus in determining whether there's a compelling interest for this statute?
It is unfortunately not part of the calculus because while one could perhaps weigh those interests against one another and might find in another context that national security does weigh more heavily, the First Amendment puts its thumb on the scale. It puts its thumb on the scale decisively in favor of uninhibited, open public expression. I see I'm out of time, Your Honor. May I briefly conclude? Thank you very much.
Thank you, counsel. Now we'll take the case under advisement.
All rise.
I think we can clap now. All right, while the judges deliberate, there are a few students here on the stage that need some introductions. So let me tell you a little bit about them. All four of our competitors are 3Ls, which is interesting because this competition was won by two 2Ls last year. All four have been or are George Washington scholars, which puts them in the top 15% of their class. This was also interesting to me. I've been doing these introductions for 11 years. I can't think of that ever happening before. All four are on a journal. All four have been or are currently LRW research and writing fellows. So there's clearly a writing theme here. I know when I've coached teams with Professor Spanagle, he's always said that it would mean a lot more to him to win best brief than he would to win the competition. So you've definitely got some writing here. All four were in the same section with their partner when they were 1Ls, and two of them were in their same tiny little LRW section together, and none of them have ever won an advocacy competition before, although three of them have been semifinalists, so someone's gonna stop being a bridesmaid today and become the bride. I asked each of the students to write their own introductions. They were a little boring, so I've added a few things. All right. First, we're going to start with Tyler Evans, who I'm going to go in the order that they spoke. Tyler grew up in Deep South Texas. He's the senior production editor of the George Washington Law Review. As noted, he's one of the three that reached the semifinals. He's a semifinalist last year in the government contracts moot court competition. Professor Schooner wanted me to note that he's a glutton for punishment. He signed up again for the government contracts moot court this semester. Schooner also wanted me to note that only 2 students have won Van Vleck and government contracts, and he wishes Tyler the best in the more important competition later this semester. Upon graduation, Tyler will be clerking for the Honorable Marion Blank Horn at the Court of Federal Claims, and his mother, Ruth Evans, is in attendance today. Tyler, why don't you stand up just for a moment? His teammate is Matthew Radler. Matt's introduction to law and the reason he became interested in the field happened overseas. He first learned about the basics of civil and criminal procedure while working as an intern court reporter at a daily newspaper in Johannesburg, South Africa, during his junior year at Northwestern. This training paid off, both from a legal and a writing perspective, in that he is now the editor-in-chief of the George Washington University Law Review, and his note will be published in the forthcoming volume of the Law Review. He was a semifinalist in the Cohen & Cohen mock trial competition, and like his partner, will have participated in 3 competitions while he's here. And in attendance, rooting him on, is his mother, Judith Radler, and his girlfriend, Aubrey McCullen. Matt, why don't you stand up just for a moment? And directly to my right, Devin Anderson. Devin and his wife, Marian Isabel, who is here today, are parents of 2 children, Claire, who just turned 3, and Khalib, who is almost 5 months old. He's a native of Mesa, Arizona. He graduated from Brigham Young University with a double major in economics and Russian. He speaks Russian fluently and was disappointed that that did not come in handy today. He enjoys keeping up with Arizona sports teams, which make for some late nights. He also enjoys hiking, playing the piano, basketball, and golf. He was a semifinalist in the spring 2010 mock trial competition. He was also a co-chair of the Religious Freedom Moot Court competition, and upon graduation, he will clerk for the Honorable G. Murray Snow in the U.S. District Court for the District of Arizona in Phoenix. His parents, Brad and Ida Anderson, along with his wife, have come to watch him today. Devin? And finally, Sam Cowan. Sam at least got in the spirit of what I wanted by at least giving me a little something to work with here. Sam is an avid baseball fan. Although originally a Chicago Cubs fanatic, he recently shifted his allegiances to his new hometown team, the Washington Nationals, and as a result, he named his dog Zim after third baseman Ryan Zimmerman. His article will be published in the next volume of the GW Law Review. Upon graduation, let me make sure I get all this right, he will be first clerking for the Honorable Anthony C. Epstein of D.C. Superior Court. Thereafter, he will clerk for the Honorable Mary Ellen Barbera of the Maryland Court of Appeals in Annapolis. And after that, he will decide whether to take an offer to join Hughes, Hubbard, and Reed. And his parents, Mark and Merrill Cowan, and his girlfriend, Lauren Pick, are here to cheer him on today. Sam?
You may sit down.
Getting really good at this.
We'll choose you as Chief Justice.
Well, thank you. Thank you to the four of you. You were just fabulous. I think we will all find different ways of saying that, but I'll just, you were terrific. Your briefs were terrific. Your arguments were terrific, and I'll be more specific and give you some criticism as well, but you should all feel incredibly proud of yourselves. I know this has been a long haul, this competition, and you should feel amazing to have gotten to this place and to be sitting at those two tables, but you should also be extremely proud of how you did today. So congratulations to all of you. And thank you. And thank you to the audience as well. So thank you all for being here, and all the families and friends in particular. So we're going to speak a little bit about the briefs and the oral arguments and the process of doing this. And then at the very end, we're going to keep the suspense going as long as possible. At the very end, we'll announce the winner. Somebody has to win, right? The winner. Justice Periente.
Well, first of all, I want to thank the Dean and all of those that organized this moot court competition. As I think most of you know, George Washington is my alma mater. I graduated a very long time ago, 1973, and the law school, the look of the law school was different, and the students. But it has been something that I've always been proud of, which is the professionalism and the high level of intellectual pursuit of this law school. You know, and I have, since I have been an appellate court judge and a Supreme Court justice for about 18 years all total now, and so we preside over many oral arguments, moot courts in Florida. And as long as this isn't going to be broadcast on the internet down there, I will tell you that the level of first of all, the problem and the level of the briefs and the level of the advocacy really was superb. So I commend you. I think one of the things that I want to just emphasize, so I'm not going to go specifically on critiques, but I want to just talk generally. What you all exhibited were two things, a high level of professionalism and a high level of preparation. You became, because you have spent so much time with this case, the world's expert on the case. And your purpose as advocates is to enlighten the court on the difficult issues that we have to confront, on whether it's a state Supreme Court or an intermediate appellate court, or for sure on the United States Supreme Court. And sometimes that's not that easy. And I think you all, we were thinking about this, you were all responsive to our questions. You all anticipated, I think, some of the tough answers, although I don't know how you felt when you got some of Justice Kagan's questions first out from the government. We were trying to think about whether our questions became more difficult as the argument went on. But your role is really, when you're preparing for oral argument, to think of what is the question that I wish that judge will never ask, and make sure you have an answer for it. Because if you can't respond to the weakest part of your case, you're likely, and that weak part of the case is the case. Obviously, it can be fatal. I think that the other part, I would say to all of the students here, as your 1Ls, 2Ls, 3Ls, there's many things that have changed in the practice of law over the time that I've been a lawyer, and many of us bemoan the lack of professionalism. But so that from my point of view, I hope that the idea of being a lawyer, which is a privilege, equates also to carrying forth your obligations in a high level of professionalism. And the first way you do that is by being prepared. And I don't know that there is any substitute for preparation. I mean, you may be natural-born advocates, you may have better advocacy skills, but in the end, the written word is also very persuasive. And I commented, to me, I thought the level of the briefs in this case were excellent. And I think, again, you may get some specifics. But courts read lots of briefs a year, especially in the intermediate level. And so you have to be able to learn to write concisely and precisely, and without using string cites. And you don't have to refute the other side's argument by actually saying, well, this is their argument, but I disagree because. You make your argument in a very direct way. So I commend the moot court competition. Whenever we end up deciding here's the winner and here's the loser, it really, you may have heard this before, and it does sound trite, but you really are all winners to come to this stage in this competition and to have just imagine arguing before a justice of the United States Supreme Court. This will be an experience you'll remember forever. I know I will, just sitting with you, Justice Kagan. And so hopefully you'll carry it forth and not worry about, well, did I win or lose this particular competition? But I really won because I was true to the basic beliefs of our profession, which is, again, the utmost in intellectual integrity and professional integrity. So thank you.
Justice Hartz.
I should start by mentioning something that may lead to your disregarding everything else I'll say, but my first, I doubt if Justice Kagan remembers this, but my first conversation with her was when she was dean at Harvard Law School, and she asked me to judge on a moot court, and I declined very politely. I haven't learned how to say no to Alan Morrison yet, and I'm so glad he invited me, even though I realized that somebody had to fill the third seat when you had the 2 stars here. But it's really wonderful to be here and to see this quality of students. We just it gives us hope for the future, and I think judges enjoy participating in moot courts at this quality because you do see the appellate stars of the future if you choose to proceed in that direction. Let me say a few things about oral argument. For those of you in the audience who might not have been fully briefed on the substantive issues, the advocates today were just terrific in the way they made their presentations. They all spoke well, they responded well. Just the manner is the sort that will give a court confidence. It would be nice if everyone could have Mr. Evans' voice. You should, if you decide to become a radio announcer, that would be. One thing I always like to criticize when it comes up, but it didn't. You all spoke fast enough to get a lot of thinking in, but be careful about not speaking too fast. None of you were flawed in that respect, but it's a common occurrence. And my favorite story about that, which I'll mention to you, is Steve McAllister is an appellate specialist. He clerked for Justice Rehnquist, Chief Justice Rehnquist, I believe, and he's been the dean at Kansas. He teaches an appellate advocacy course at Kansas. And once he found himself in the Supreme Court arguing against one of his former students. And the student was the petitioner and had spoken a couple minutes when Dean McAllister handed him a note while he's talking to the Supreme Court. And it said, "Slow down." So that's a very important, but I don't have any suggestions to you on your oral advocacy. The briefs were also excellent. I do have one comment, because it's not uncommon for this to arise. You're drilled on how you need to be intellectually honest in your brief, don't overstate it, make sure you acknowledge the opposing authority. I thought both of you overdid that a bit and started by talking about what the opposing law was. Work that into your argument, explaining why this case is different from that. You were too honest in a way. But that's really the only thing I could say about the briefs. But this has been the last thing. The last thing I wanted to mention was one of these teams will be awarded the honor and the other will be second place, and that will be disappointing to the second place team. I would like to talk to that second place team, whoever it's going to be, because I don't know any people who have won. The people I run into are the second place teams. And for example, I sat on the standing committee for rules of practice and procedures for the federal courts. And two of the people I got to know well were Second Circuit Judge Rena Raggi and Robert Hinkle, who's a federal district judge in Florida. And I learned that they were moot court partners together and came in second. One of my clerks this year was runner-up in moot court. And once, a couple weeks before I was going to Wake Forest to do a moot court, I was talking to a lawyer friend in Albuquerque, where I live, and I mentioned where I was going, and I knew that she had gone to Wake Forest, and she says, "Oh, I was the runner-up in the moot court." She was so proud of having been runner-up, and particularly given how many people are competing and what level you've reached, there's no loser today.
Thank you. So first, let me say just what a pleasure it was to be here with Justice HARTZ and Justice Pariente. I had forgotten, Justice HARTZ, about that conversation, so I don't know why you reminded me of it now. But you guys were just terrific, and I'll sit on a bench with you anytime, and thank you very much. So, again, just to repeat some of the things that Justice Pariente and Justice HARTZ said, you were quite marvelous. Your oral advocacy skills, all four of you, very, very high. And I think I've never done, this is my first moot court as a judge, but I saw a lot of moot courts when I was dean and when I was a professor. And it's usually the case that there are just differences in their presentation and their skills as oral advocates. And we all three went back to the room and said, boy, those guys were just so good in terms of being unflappable, in terms of being poised, in terms, as Justice HARTZ said, of sort of speaking at the right pace, with the right kind of tone. Really quite extraordinary in that respect. In oral advocacy, I think the most important lesson is to view questions as opportunities and to think about truly how you can engage with a question and how you can respond to a question, rather than how you can kind of get a question out of there and go on with what you're really wanting to say. I mean, questions are hard, and that means that while you're standing there, you just want to push them out of the way and get to the easier parts of your argument. But in fact, when judges ask questions, it's because they're having trouble with some aspect of your argument. And it doesn't matter that you can recite the easy parts of your argument. What matters is that you can engage with them and try to convince them on the thing that's most troubling them. And so it's a real temptation always to try to sort of do a quick answer to a question and then pivot as soon as you can. And sometimes that's the right approach, but often you just have to think about what is concerning the judges rather than what you think are your three strongest points. They probably know your three strongest points already, and what you have to do is convince them, us, that in addition to having three strong points, the problems that we see in your argument aren't real. And so I think that that's the thing that I would say to all of you is that if you can just sort of keep on thinking about that as you're doing an argument, not to give in to the temptation of, as quick as I can, get away from this really hard question. But, to try to engage as well as you can. And, it doesn't mean you have to, spend all your time talking about your weakest link. But I think that that's would be what I would say to all of you in terms of arguing. Your briefs were excellent. I would reiterate, all three of us, when we went back there, had this feeling of, I think they took a little bit seriously this idea of, giving the other side its due. For sure, you have to cite cases that are relevant and that cut against you, and you can't ignore opposing authority. That's a really important part of professionalism. But sometimes I lost track of which brief I was reading. For sentences or a paragraph at a time until I got back to your argument rather than your sort of saying so I suppose that's a little bit the opposite of the oral argument criticism. It's like in your briefs you were sort of too much on the other side's team. So I think we all had that response. And then the second thing that I would say just about the briefs, and parts of the briefs were better and parts of the briefs were worse at this, and I won't rank it, but the most important thing that a brief can be is clear. If I have to read a sentence over, you have messed up. The most important thing is to write a brief which just is smooth and which flows, and where I never have to think really hard about what you're saying. Now, that's unbelievably hard because law is hard and because these problems that you're being given are hard. And it's hard to express hard things in easy prose. But that's what you have to do. And to do that, you have to write and rewrite and try to figure out what the world looks like to a person who hasn't been thinking about a particular problem for as long as you've been thinking about it. Because as good as the judges are, you know the case a ton better than they do. And you know the precedents a ton better than they do. And they're coming to it sort of as generalists, right? You're coming to it as a specialist. And when I pick up a brief and I never have to say, wait a minute, what is this brief saying? Or wait a minute, I think I have to read that paragraph again. That, to me, is the most successful kind of brief that there is, and that's what you should be sort of striving towards. And it's sometimes really difficult because you're so in the problem, you're so in the weeds, that it's hard to know what's clear and what's not clear. But if you try to sort of put yourself, say, I'm just going to try to approach this as a normal human being, you know, who hasn't thought about this issue for the last however many hours. And, you know, is every sentence that I'm writing crystalline in its clarity? That's the most important thing for me. Okay. The best team, which is the best team? The best team is the red team. And that was the respondents, the red brief, the respondents. Mr. Anderson and Mr. Cowan.
I don't think they thought of themselves until they... Boy.
And now, I will say it was a split decision. So it gives you a little peek behind the curtain. It was 2-1. So you know it was close because it was 2-1.
Can't get any closer.
Can't get any closer. The reason the respondents won actually had more to do with the brief than with the argument. As I said, we all thought that you were just amazing at the argument, and it was hard to pick them if you had just thought about the argument. So the reason the respondents won did have more to do with the brief, and what we thought as well is that we would give one other recognition to one member of the respondents' team for that part of the brief. And Mr. Cowan, that goes to you. And the reason that goes to you, it partly has to do with you and it partly has to do with the situation. Mr. Cowan, of all four people, you had the toughest road to hoe here. You just had a bad argument to make. And what all of us were impressed with was how you made a bad argument seem kind of okay. for at least a moment in time. So, Mr. Cowan, hats off to you for that. That is a really hard thing. You know, you go up there, and before I became Chief Justice, I was Solicitor General for a year, and sometimes you have a strong case, and sometimes you have a weak case. And most of the time, you're going to win the strong cases and lose the weak cases, and it has nothing to do with either your brief writing or your advocacy. This was just, we just thought that you should have a little bit of extra recognition, Mr. Cowan, for taking a tough assignment and doing a truly excellent job on it. So, thank you all very much. All right. Anything else? We're done. Thank you all.
Thank you.
Not done?
We're done. Good afternoon. My name is Julie Fleischman. I'm the president of the GW Law Moot Court Board. I wanted to thank you all for attending the competition today. I hope you enjoyed it. I'd like to take this chance to recognize a few individuals for their contribution to the Van Vleck competition. First, a thank you to Sean and John. I don't know where Sean is. John's up there. And Sean's down here for writing such an interesting and challenging problem, as well as to Dean Morrison for helping them throughout that process. I'd like to also thank Dean Johnson for coordinating the entire competition from start to finish, as well as to Emily Walters, who was out here earlier, for being the Vice President of Internal Competitions. She helped run this from the preliminary rounds up until the final round today. Finally, on behalf of the Moot Court Board and the student body, I'd like to thank Justice KAGAN, Justice Pariente, and Judge HARTZ for volunteering their time today and making it a very successful moot court. As a token of our appreciation on behalf of the Moot Court Board, we'd like to present you with a small gift. We made sure it was within the judicial guidelines. So,
Can I say one thing before you do? Sorry about I know I'm ruining the program. I just want to thank all the other students who made this event what it is. I was dean for a lot of years, and I know that these guys, they get to do the star turns, but there are a ton of other students whose hard work and energy and dedication have made this event what it is, and hats off to all of you.
Thank you.
and we also have a special gift for Justice Pariente. We have a GW alumni sweatshirt for her. So.
All right.
So former Dean Kagan stole my line. I was actually going to thank all of the other people students who behind the scenes have worked both on Moot Court Board and all of the students who were part of this competition all the way along. Again, this is a very large school effort, and so I want to thank you all for making this such a successful event. I also want to note, this is one part of what might be called Supreme Court, U.S. Supreme Court year at GW. We had Justice Thomas here all fall teaching a class every semester, every week during the entire fall semester on looking at important cases from constitutional history and looking basically behind the scenes and behind the decisions to look at the real historical context, and he co-taught that with Professor Greg Maggs. And then we had Justice Scalia here to give a talk as part of our Law Review Symposium. And then in a month we will have, I believe it's 5 more justices of the Supreme Court, of the U.S. Supreme Court, and 3 or 4 judges from the European Court of Human Rights having a summit here, part of which will be open to students and part of which will be a closed-door meeting among those judges. And so we're pretty much going to have the entire Supreme Court here during the course of just one term. And it's, again, part of this idea of law in action that I talked about before the argument, that connection constantly to these important events and people and activities is, I think, part of what makes this law school unique and distinctive. So I want to thank Justice Kagan for being here, and I also want to thank Justice Pariente for coming back to her alma mater, and I want to thank Judge HARTZ for being here, and I hope you will all be back in the future for further competitions and other events, and so you are now honorary GW members, all 3 of you. Thank you all for coming. We'll see you at the reception, those who have tickets.